How long does divorce take? Well, there's a minimum. It's going to take, at the very minimum, 6 months and 1 day. 6 months, cooling off period, and 1 day to file that judgment. Out of 100 divorce cases, what's the percentage of divorces finishing in 6 months and 1 day? I can hold up with one hand, one finger, about 1% of the time. Divorces can take a year for judgment. They can take 2 years for judgment. They can take 10 years for judgment or more. And I've seen it happen. You have two parties that have enough money to fight it out, they'll go for years. It's a waste. What a waste of time. That's money that can go to their children for their education, for their best interests. Instead, the parents will fight. They'll make it like a war, what they call a war of the roses. Two people that used to love each other now just spending every penny they have to make the other side miserable. That's where having a good attorney helps. We can cut through that, and Real Father's Rights can help get you to the other side a lot quicker. What are the legal steps in going through a divorce? Well, we follow the United States and the California Constitution. That means process. That means a service of process. That means you file a summons and a petition for a divorce, and you get someone to personally serve the other side. They have 30 days to file a response and have you served. And then the process begins. At that point, the parties can hire attorneys and they can meet and come up with an agreement if they want and never step a foot in court. More often than not, though, if there's one or more issues that the parties can't agree upon, they'll file something called a request for order, which will get them in for their first day of court. In the morning, usually. It's not a trial. It's just a chance to state your case under declaration and bring in a bit more argument for the judge. Or the judge makes something called temporary orders. It could be for custody, visitation, support, spousal support, alimony, child support. It could be for a temporary division of property. Just about any legitimate reason involving a divorce that you need quicker orders, you can get into court and get those orders made or get those orders denied. The goal is to get a judgment, and that takes at least 6 months and 1 day to do. More often than not, it takes a year or two to get a judgment done and finalized. And that's what the goal is in filing and receiving a summons and petition for a dissolution of marriage. To get to the end process, to get to that judgment phase. That's something we can help with quite a bit here. We've done quite a few divorces at Real Father's Rights. We know every step there is to get you from beginning to end. Let us help you. What documents do you need to prepare? In California, they use judicial council forms. These are prepared by the state legislature and by the court systems to make the divorce process a little easier, especially easier for the judge, because they can recognize the actual prepared document, the pre-prepared document, and be able to know what they're looking at in front of them on the table. These documents are petitions, their responses, their declarations. I always say that the important concept is not so much the document itself, it's what you put in them. Sworn declarations, you're going to be putting in your story, your set of facts. Hopefully those set of facts are the truth, because those are made under penalty of perjury. And they make it a lot easier than the old days where you had to type up the form from scratch into what we called a pleading. These are actual pre-prepared pleadings, not pleadings from scratch that you have to type out. It's a much easier process to use these court documents. What is mediation? There are two general types of mediation in the courts. One of them is very popular if there's a legal battle for children. It's family court mediation, specifically for custody visitation issues. In Riverside County and San Bernardino County, these mediations are for what we call reporting counties, where the mediator will call in the mother and the father to state their case for custody of the children. And in these two counties, Riverside and San Bernardino, it'll be reported to the court, a recommendation from these counselors that talk to the two parents. This mediation will make a recommendation for temporary orders for custody and visitation, which more often than not will carry into a permanent pattern of who gets the children and when. LA County and Orange County are non-reporting counties for mediation. So you can go to mediation to see if you can come up with an agreement. And in this case, if you don't come up with an agreement, the mediator will not make a recommendation to the courts, and pretty much the courts will start from scratch. The other mediation, it's voluntary. It's a settlement conference where you can use a court-appointed mediator to settle all the issues of your case. Usually it's more property-centered. Who gets the house? Do you have to sell the house? How are you going to divide the retirement accounts? How are you going to divide all the junk that's in the house? Sorry, not junk. These are precious items of yours. But who's going to get what? Court-appointed mediators are good for that in a voluntary settlement conference basis. It doesn't cost anything but time and paying your attorney to be there for such mediations. You can also, on rare occasions, when it's a high-value asset-driven divorce, hire an outside judge, a private judge, to mediate and make a decision. Sometimes they're called arbitrations, where they'll make an enforceable order for the court to follow. Usually, though, we don't extend ourselves out in divorces to being at the mercy of a private judge. We look to them for making agreements. The private mediation is used with a judge for high asset division for the most part. It can encompass the entire divorce using a private judge. It's also expensive. These judges can cost $7,500 to $10,000 a pop for an all-day session. However, that's a cheaper alternative than going to trial at times. Trials can cost even more than that. What to expect in court? If you come to court with family, with children, with assets, you own a house, you own a company, a business, you're in a long-term marriage, and you have a spouse that's making similar claims to what you're claiming in terms of custody, visitation, support, and property, you can expect a hearing, 2 hearings, 3 hearings. You can expect a trial. It might be a trial on who gets the children or how you share the children. It might be a trial on how you divide the property. What you can expect is sometimes a slow and painful process and expensive. It could be expensive to your time. It could be expensive to your pocketbook. Hiring a firm like Real Fathers Rights, we can pare down the issues. We can negotiate out those issues that are near negotiation, near agreement, and we can make sure those don't become trial issues, working with good counsel or working with the party on the other side. We can make the trial process a lot less painful and a lot more direct and a lot more centered to getting you what you want to get without distraction. Here at Real Fathers Rights, when you have one of our attorneys on your side, we will cut down the noise. We will stay focused on getting you the result that you want. We will try our hardest to get you the result you are looking for.